Thank you, Your Honor. This is case number IT0482A, prosecutor versus Boškoski and Johan Tarčulovski.
I'm to ask Mr. Boškoski whether he can follow the proceedings through the translation. And Mr. Tarčulovski, are you able to follow the proceedings through the translation?
Yes, Your Honor.
Thank you. May I have the appearances now for the prosecution?
Honours, good morning. Paul Rogers, appearing for the prosecution together with Laurel Baig and our case manager today, Mr. Colin Narrott.
Thank you. And for the defense of Mr. Boškoski?
Good morning, Your Honours. Edina Rashidovic, lead counsel together with Canal Metro, co-counsel representing Boškoski.
The defense of Mr. Tarčulovski.
Nathan Dershowitz, on behalf of Mr. Tarčulovski, along with Jordan and Antonio Mapetovsky.
Thank you very much. Today, the appeals chamber delivers its judgment in this case. And following the practice of the tribunal, I will not read the text of the judgment except for the disposition. Instead, I will summarize the issues on appeal and the findings of the appeals chamber. This summary is not part of the written judgment. The written judgment is the only authoritative account of the appeals chamber's rulings and reasons. Copies of the written judgment will be made available to the parties at the conclusion of this hearing. The case concerns the events during and subsequent to a police operation conducted on the 12th of August 2001 in the village of Ljuboten, situated in the northern part of the former Yugoslav Republic of Macedonia, also known as the FYROM, and I will refer to it as the FYROM. At the relevant time, Boškoski was the Minister of the Interior of the FYROM, and Johan Tarčulovski was a police officer. The trial chamber found Johan Tarčulovski guilty of ordering, planning, and instigating murder, wanton destruction and cruel treatment, all violation of the laws or customs of war under Article 3 of the statute. He was sentenced to a single sentence of imprisonment of 12 years. Boškoski was acquitted on all charges. Mr. Tarčulovski has presented 7 grounds of appeal challenging his conviction and sentence. The prosecution has appealed Mr. Boškoski's acquittal. I will first address Johan Tarčulovski's grounds of appeal and then turn to the prosecution's appeal, following which the disposition will be read. In his first ground of appeal, Mr. Tarčulovski submits that the conflict in the FYROM during the relevant period between FYROM security forces and the National Liberation Army, also known as the NLA, did not reach the level of an armed conflict, as it did not meet the threshold requirement of intensity. The trial chamber did not err in concluding that the intensity of the conflict in the FYROM and the NLA's features identifying it as an organized armed group were such that an internal armed conflict existed in the FYROM in August 2001. The appeals chamber sees no error in this finding. Mr. Tarčulovski further contends that the tribunal's exercise of jurisdiction over this case is improper, as the tribunal did not determine whether the government of the FYROM lawfully ordered the operation in self-defense to root out terrorists from amongst the villagers. Moreover, he argues that the exercise of jurisdiction by the tribunal is contrary to the actions of the United Nations Security Council. The appeals chamber considers that the fact that a state resorted to force in self-defense in an internal armed conflict against an armed group does not, in and of itself, prevent the qualification of crimes committed therein as serious violations of international humanitarian law. Moreover, the United Nations Security Council did not state that the situation in the FYROM was outside the tribunal's jurisdiction. Consequently, this ground of appeal is dismissed in its entirety. In his second ground of appeal, Mr. Tarčulovski submits that the events in Ljuboten on the 12th of August 2001 did not violate the laws or customs of war, since they were the result of a sovereign state's legitimate and proportionate response to an internal terrorist attack. He also questions the applicability of the laws or customs of war in determining individual criminal responsibility for a person assigned to carry out a legitimate operation planned by a sovereign state. The appeals chamber finds that the application of rules applicable in armed conflict is not affected by the legitimacy of the use of force by a party to the armed conflict. And therefore, the fact that a state is acting in lawful self-defense against terrorists in an internal armed conflict does not render common Article 3 inapplicable.